Good afternoon, my lords. The final ground of appeal for which Mr Costa obtained permission concerns the parameters of the proposed quantum trial, with which you lordships are now very familiar. So, of course, this ground is all on the footing that we fail on our appeal, which, of course, is seeking an unconditional buyout. If the order is to be unconditional, as in a conventional buyout, then there would be no need for any counterfactual inquiry, which is the basis upon which these parameters have been inserted. We would just have a normal quantum hearing with expert evidence as to the value of the company as at the end of 2019. The schedule to the order identified 12 parameters. As the court knows, they include a direction that there would have been at least one binding offer for the company by the end of the year. And you've seen the transcript about the discussion with the judge at the consequentials hearing in respect of that paragraph of the schedule. So this appeal, on the other hand, concerns three of the other parameters: paragraph 4, paragraph 6, and paragraph 7.
Just out of interest, does that parameter, the first one, that there would have been an offer at the end of the year, does it actually help a valuer? Does it take a valuer anywhere?
My lord, I would suggest not very far on a conventional valuation. I mean, clearly the valuers will be looking at the market and comparable companies. Insofar as it might be suggested there was no market in a company of this kind, possibly that finding may be of assistance, but I don't suggest it goes much further than that. In respect of each of these heads, the thrust of the argument is that it was wrong for the judge to hold Mr Costa, who of course is the party against whom the order is made, wrong to hold him solely responsible for the company's default. So it said that the only appropriate parameters are those that reflect matters that can be laid at Mr Costa's door. We say really it's just another attempt to resuscitate the idea that it was the board, not Mr Costa, who was responsible for the matters about which complaint is made, when in fact it's perfectly clear that Mr Costa was entirely responsible for the conduct in issue. And in fact, he was found to have been obsessed with maintaining control of the process himself and was actively hostile when attempts were made by others, including members of the exit committee, to become more involved. So we challenge the underlying basis for this appeal against any of these parameters. But just dealing with them in turn as quickly as I can. Paragraph 4 of the schedule, that's in the following terms, that the company should have instructed Jeffreys that it was required to seek offers for an exit by the end of 31st December 2019. That's the fourth parameter in the order, which, just so you lordships have it, it's at page 165 of the bundle. And the appeal against this counterfactual, that Jeffrey should have instructed to seek offers by the end of the year, is premised principally on what we say is the erroneous construction of clause 6.2. As your lordships now very familiar with the point, my learned friend says that effectively little, if anything, was actually required to be done by the deadline. So that is really what underlies the attack on this parameter. So we say that's misconceived. Clearly, the company was supposed to be actively seeking offers, and in those circumstances, clearly it should have instructed Jeffreys on that basis. There were certain other points made by my learned friend in support of this aspect of the appeal. For example, he suggested that nobody complained about the terms of the engagement letter, and that's transcript day 2, page 270, line 17. Now, with respect, that's simply wrong. Mr. Loy certainly complained about the terms of the engagement, specifically that the terms of the retainer were too broad, and he wanted the retainer to be redrafted so that it constituted a mandate solely focused on achieving a sale of the company, and that was dealt with by the judge at paragraphs 49 to 50 of his judgment. It is also said on behalf of Mr Costa that there is no evidence that anyone in the company thought that the company was required to seek offers by the end of the year. We say that's of little relevance in circumstances where Mr Costa himself was fully in control of the process. He ensured that nobody else, possibly with the exception of Mr Uberoy, had any real insight into what was going on. Furthermore, it's common ground, and it's recorded at paragraph 98 of the judgment, that Jeffreys themselves had always operated through Mr Costa. Furthermore, Mr Costa failed to obtain proper advice from Jeffreys or the company's lawyers. And indeed, Mr Costa was pursuing a strategy which he knew or should have known was contrary to its obligations. So, really, there's no avoiding the fact that the responsibility for failing to instruct Jeffreys on a basis consistent with clause 6.2 falls squarely upon Mr Costa, and therefore it's entirely appropriate that the valuation exercise at the quantum trial should proceed on the basis that the company should have instructed Jeffreys that it was required to seek offers for an exit by the end of the year.
Just one thing on part of what you just said, Mr Davis. I think at the beginning of paragraph 208 of the judgment, the judge sets out, when about to deal with section 172, sets out Mr Costa's position more broadly, saying his position is that he reasonably believed it was in the best interest of the shareholders for it not to comply with the requirements of clause 6.2 on the timetable specified on the basis that a considerably higher value. So that appears to be a finding that Mr Costa actually knew that the conduct in which he was engaging was a breach of the company's obligation. Of course, if his appeal is right, he might have been wrong in that belief, but nevertheless, that seems to be a finding that that was his state of mind.
My Lord, I'm grateful for that, and I think that goes to a point raised by my Lord Justice Zacaroli earlier on. Whilst the finding might have been presented more crisply, my submission, a fair reading of this paragraph, does indicate the judge was satisfied that Mr Costa knew perfectly well that he was not complying with clause 6.2. When after all, he had the likes of Mr Loy contacting him pretty frequently, complaining about the fact that 6.2 was not being complied with. So we say it's perfectly fair for the counterfactual world that the judge is seeking to create to include a direction that the company should have instructed Jeffreys effectively to comply with clause 6.2, which is what this parameter seeks to do. Then paragraph 5 is the next of the parameters that they challenge, and this is as follows: that the company should not have paused the marketing process whilst it searched for a new CEO. Now, this is again another attempt to shift responsibility for the failures of the exit process away from Mr Costa and onto the board. And effectively, Mr Costa says he shouldn't be held responsible for a pause because it was a matter that was resolved upon by the board in the connection with the proposed appointment of a CEO. That ground of appeal was rightly dismissed by the judge, we say, and it is helpful to see how the judge dealt with it, and that's at paragraph 41 of the consequentials judgment, which is at page 296 of the bundle. So paragraph 41, page 296. If we pick it up about halfway down, we see the judge saying, and this is with reference to the meeting in February 2019, the minutes of that board meeting make clear that the essence of the resolution was to instruct Jeffreys to begin marketing the company immediately, the assumption being that the new CEO would be identified within a few weeks and might be in place as early as April. There was no suggestion that waiting for the new CEO to be identified would cause the exit to be delayed beyond the target date. This resolution was absolutely not, as Mr Hill seeks to present it, a mandate to Mr Costa to down tools until the new CEO had arrived, established himself and fully taken up the reins. As I said in my judgment with regard to this point, Mr Costa cannot rely on the argument that it was the board as a whole who caused the company to breach its obligations, since the board's decisions in the matter were the result of the fact that he had misled it. So we would respectfully adopt the judge's summary of the essence of the meeting, but we can have a look at the minutes anyway, and they are at the supplemental bundle, volume 1, tab 14, page 220. And Lordships have that. You see minutes of the meeting, 28th of February at 5 o'clock. And the update on the exit process starts on page 222, item 4, exit process update.
Sorry, Mr Davis, can you tell me whether this is in the supplemental, the core supplemental, which is where I
Yes.
222.
That's the supplemental.
The core bundle. Sorry.
Forgive me.
It's tab 9.
Thank you. Tab 9.
Thank you. Yeah, got it.
Page 41. And my lord, because we're going there, and if your lordship needs it, it's tab 13 and page 71 is the June meeting. So we have this short paragraph on in item 4, and really what you see there is that they're preparing the marketing materials and the engagement letter is ready. After that, they can market the company. And over the page, Chairman explains that he is happy with the overall trends and that the company is ready for the new CEO that will take Spring to the next chapter and prepare the company for the exit process as contemplated in the investment agreement. So according to the minutes, Mr Costa is telling the board really that things are ready to go. And then there's some further discussion before the board is recorded as having resolved, and you see in bold, to circulate Jeffrey's engagement letter, pursuant to which Jeffreys will commence the exit process as soon as the new CEO is identified. And I made the point earlier on, it's not appointed, in place, feet under the table, it's just identified. It's not actually clear why that qualification was inserted, but in any event, there's no suggestion that it's seen as actually justifying any kind of delay or indeed even a pause in terms of the discussion. There's no suggestion it should mean a pause in the process. And we see from the next section of the minutes under the heading CEO Research Update that the process of identifying a new CEO is allegedly almost complete. If you look at the third paragraph of that section, you can see they've already identified 3 candidates, 3 potential candidates. And then if we skip to the top of page 224, there's a paragraph starting 4ML, which was Mark Loy. Even if they would be able to find someone very soon, this person would not be able to sit at the investors' meeting in 1 month and represent the company. For Mr Costa, if Spring goes to the meeting with the exiting CEO, it would not be productive. It would be better to wait a couple of weeks more before going to the market, but doing it with the new CEO. So there's clearly an upcoming meeting, so-called investors meeting. There's a discussion as to whether or not it should be the outgoing CEO goes or the new CEO, but the time frame we're talking about is a couple of weeks difference if we wait for the new CEO. And then reading on, for Mr Qatar, it is important to find the right candidate and not force someone down the pipe. Mr Costa and Mr Oberoi believe that the process with Jeffreys needs to start anyway. So Mr Costa...
Just to be clear, I think Mr Costa is saying 6 weeks. It's 1 month plus 2 more.
In 1 month, forgive me.
It's not 2 weeks from here, it's
Yes,
6 weeks.
I think that's fair, if I may say so, my lord. But still, we're in February. That's kind of mid-March. Yes, but my lord, that's entirely fair analysis. Forgive me. And then we have Mr Costa and Mr Oberoi saying that the process with Jeffreys needs to start anyway. So Costa's saying, don't worry about the CEO, we've got to start the process with Jeffreys.
What does that mean? Because the theory is the risk of losing Jeffreys.
Yes, so they're worried that Jeffreys, being a sparkly investment bank, they're keen to have them on board, ostensibly helping with the exit process. And it seems to be the case that Mr Costa's worried that Jeffreys will lose interest and go elsewhere.
But they hadn't been signed up yet, had they, Jeffreys? So
They hadn't.
More likely to be the process of getting them on board by the engagement letter being finalised.
The backdrop is that Jeffreys had been working with Mr Costa for some time already, so there is an existing relationship. It's a question of whether they then get specifically retained for the exit process.
So that's the process that was being talked about there, getting them specifically retained, presumably.
Yes. I'm reminded that if we go back to the previous page, under item 4, you see the chairman informed the rest of the board that Jeffreys, after almost a year, is ready to go ahead and work with Spring. They have prepared the marketing material and engagement. So they've already done some work. I think it's a case of just getting them signed on the dotted line, so to speak. As it will take some time to complete, and if everything is postponed, the risk is to lose them, Mr Costa could participate at the first meeting representing Spring. So then, to Lord Justice Snowden's point, I think Mr Costa goes back to thinking that maybe he could attend that meeting referred to in the previous paragraph instead of either the exiting CEO or the new CEO. It's not entirely clear, but
it is fairly clear, isn't it, that there's some pause in going out to prospective purchasers envisaged by the resolution of this meeting. Not the long pause you say, but does it make any difference on your case if it was a couple of months later rather than in February?
It makes no difference. Certainly, all the experts will both agree that to my conversation with Your Lordship earlier on, this wouldn't have mattered in terms of getting the thing done by the end of the year. Which we say is important context for the judge's decision to include as a parameter. Effectively, there would be no pause. I mean, either one can say he formed that view on the basis of his interpretation of that there wasn't a pause, or maybe informed by the view that it wouldn't have made any difference. One way or another, he considered it an appropriate counterfactual parameter, and we say there's no proper basis to interfere with that. And then the last of the parameters that they seek to get removed is paragraph 7, which is the judge's direction that it should be, the valuation should proceed on the basis that the company should have given due consideration to the offer from Metric. So Mr Costa says that's not an appropriate parameter, but this is basically premised upon his erroneous construction of the meaning of exit, which I discussed before the short adjournment. His position is that the Metric offers didn't warrant any consideration because they weren't for an exit. And I hope I've debunked that hypothesis. And so there was every reason for the judge to include this as a parameter. So that's what I have to say on ground 4. If we get to this point, which in our case we don't, because we hope to succeed on our appeal, and this court is considering what's to be done about the quantum hearing in terms of the parameters, we say that these parameters are perfectly sound and should be maintained.
That's only, presumably, though, on the basis that the aim of the quantum hearing is to replicate the position that your client would have been in if the company had not breached.
If things had been done properly, yes.
Shareholders Agreement.
Yes.
Because if the alternative way I think you put the case certainly seemed to get on Tuesday, is that in the alternative, there were other things that were done that the judge found. Say, for example, the breach of fiduciary duty, which would have justified what I'd call a conventional buyout order. Then none of these parameters matter.
Correct.
Because in those circumstances, you just fix a date and you say to the valuers, just give us the open market value of the company as a whole as at that date.
Absolutely right, my lord. So the only reason we're doing this is because the judge's view that he had to be satisfied there was financial loss. Therefore, one needs as my Lord Zacaroli describes, a causation trial, and that has to be premised on a counterfactual world. So these parameters are simply designed to create a counterfactual world in which that causation trial.
I know you say that these parameters are all good and fine and dandy, but just as a matter of pragmatism, or just asking you, which is the preferred approach?
I think
the two that I've outlined. Our preferred approach would be a conventional valuation trial with no counterfactual directions given to the valuer, and they just value, as one quite frequently sees in unfair prejudice quantum trials, they value the company, as your lordship said, at fair value as at a date. It does, for the reasons I developed a little bit on the first day at least, conceptually I would suggest it complicates matters for an expert to also be involved in some counterfactual analysis as to process rather than just looking at the value. So I think we would consider it a certainly more conventional and easier process for the valuers just to be valuing the company as at a date with whatever financial material is agreed should be before them. So that completes my treatment of my learned friend's appeal. I'm now going to reply on Saxon Woods' appeal, starting with section 172. It was suggested that it had come as something of a surprise that we were relying on breach of 172 as a freestanding ground of unfair prejudice. Insofar as this stemmed from a reference to us relying on it as a ground of unfairness only, I struggle to understand the point with respect. Obviously, under section 994, you need unfairness and prejudice. The unfairness can be established in various different ways, including breach of director's duties. So we rely upon 172 to establish the requisite unfairness, and we then allege and plead that Saxon Woods has suffered prejudice as a result of the various aspects of unfairness that we complain of. And that's the pleading in paragraph 137 that we looked at. And that I should just say, is in entirely conventional form. And we just took the trouble to make that point good by including in the authorities bundle the statutory instrument on the company's unfair prejudice applications. It's at page 34 of the authorities bundle, and you see there the company's unfair prejudice applications proceedings rules. And paragraph 3 of the rule says the petition shall be in the form set out in the schedule to these rules, with such variations, if any, as the circumstances may require. Sub 2, the petition shall specify the grounds on which it is presented and the nature of the relief which is sought by the petitioner. And then if you turn through a few pages to page 37, it's quite small print, but there you have the schedule of the standard form unfair prejudice petition, which I confess is rather shorter than the version we see usually, and certainly in these proceedings. But you can see there is a standard form for the prejudice aspect. In these circumstances, your petitioner submits that the affairs of the company are being conducted in a manner which is unfairly prejudicial to the interests of the members, etc. So that's perfectly standard form. And in any event, it was made actually rather clearer in the petition, and I possibly should have picked this up as we were going through, but my lords, if you please could turn to the petition.
tab 15, page 305 of the core bundle. A few pages in, paragraph 28. Sets out in summary the matters of complaint. And you see sub 1 deals with clause 6.2. Sub 2, further or alternatively, Mr. Costa's conduct in relation to the purported exit process involved breaches of the duties which he owes to the company as a director.
So did I hear? I must have heard the page reference wrongly.
Sorry, my lord. We're now in the petition C314, which is paragraph 28. Paragraph 28 of the petition. And it's under matters of complaint. And very shortly, subparagraph 2 and subparagraph 3 are the relevant ones. And clearly, the breach of fiduciary duty is put forward as the freestanding ground upon which we rely for unfair prejudice. And the point was also made in our closing submissions, which are at the supplemental bundle tab, file 2, paragraph 48, page 978. So it's page 978 of the supplemental bundle, paragraph 489. Well, actually, starting on page 977, you see a heading H, Mr. Costa's responsibility for the unfair prejudice. Then paragraph 489, the allegations of breach of duty are freestanding complaints of unfair prejudice, as well as grounds for holding Mr. Costa responsible for the unfair prejudice. So there it is. We consider the position was perfectly clear.
Where's the pleading of what prejudice was caused by the conduct?
Well, my lord, we would say you don't have to plead out all of the prejudice that you say has been suffered.
We've seen certainly some authority which says that there must be causation between the conduct and the prejudice.
Yes, so we would, that's true. So we don't have the paragraph consequences of the unfairness, which we do see specifically in relation to the breach of clause 6.2.
The judge said your case was squarely, prejudice was being unable to exit in accordance with the agreement.
Yes, and we would say it's the breaches of fiduciary duty have caused the same prejudice, and that's captured by paragraph 137 and the immortal words in the premises.
But if the same causation is relied upon, whichever foundation of unfair prejudice you're relying upon, then we come back to the judge's conclusion that, well, you need to establish causation. Therefore, if there would not have been an exit in the counterfactual world, there's either no prejudice or there's prejudice but there's no relief granted.
Well, I can see that the analysis in respect of causation should be the same under both heads, if you like, of unfairness. I would accept that.
Right. So you're not. Well, are you submitting? I thought you were. That if you can establish that Mr. Costa's conduct was also a breach of fiduciary duty, you can circumvent the requirement the judge imposed of saying that the unfair prejudice led anywhere, as in
I think
you wouldn't have exited.
To this extent you can. You don't have to rely upon some analysis concerned with the mechanics under clause 6.2. So as far as the judge's concern about the shareholders ultimately being those who get a free hand as to whether or not to accept an offer was related to his conclusions in respect of clause 6.2, you avoid all of that, and you have you're able to say that there's unfairness and prejudice by virtue of being locked into a company that that is being run by a wrongdoer, someone who has breached their fiduciary duties to you, and that is a sufficient basis in itself for a buyout, and that would be a normal unconditional buyout.
So that does completely bypass the judge's conditions.
Yes.
Because you're saying,
but your lordship's correct. That's not spelt out. That aspect is not spelt out in the petition.
That's the basis of the question I asked you, is if the basis of ordering a buyout is breach of fiduciary duty, simpliciter, you don't need to try and replicate the contractual position you would have found, the position you would have found yourself in if the contract had been performed.
And I think that's informed the judge's approach, because he saw this as akin to a breach of contract situation, which I think was the point I was groping towards with my Lord Justice Zacaroli. I would suggest that the reason the judge arrived at a counterfactual kind of analysis was he was focused on Clause 6.2, breach of Clause 6.2, and was any financial loss.
He had to, because he didn't find a breach of fiduciary duty. So
yes, so that was his approach. If you're approaching it as a breach of fiduciary duty, you avoid any kind of contractual analysis. I absolutely adopt my Lord Justice Snowden's point, and it conceptually, in a sense, it's simpler. Having said that, it's true that the petition does not spell out specific prejudice other than the loss of the exit pursuant.
Or you'd say it's the loss. I think what you have to say is the loss of the opportunity to exit.
Yes.
Because if in fact, looking at the matter as a matter of causation, and it depends on the interpretation also of 6263, but let's assume that there would not have been an exit even if the contract had been performed, because, for example, there's no obligation upon shareholders to sell. Let's assume that interpretation of, at any price, let's assume that is interpretation. The frustration of the process in breach of fiduciary duty would, you say, I think, nevertheless give you an entitlement to a buyout, because you, especially if that frustration had been done in a particularly egregious way.
Yes, it's the Edwardian group type of analysis. There are other cases that one can choose, but certainly we'd say it fundamentally undermines the basis.
You were going to say trust and confidence, but that it's not a quasi issue.
And I was then going to say the basis upon which they participate in the company.
Yeah, which is the more conventional way that Lord Hoffman looked at it in.
Indeed, yes. So the argument runs both in a quasi-partnership context and where you've got a shareholders agreement.
Then it's a matter for discretion for the judge as to whether what's been done is sufficiently bad.
Fair enough. To make it fair and appropriate for there to be a parting of the ways through a buyout order.
Yeah, as opposed to some other more targeted relief that leaves the two people together.
My Lord, yes. Yeah. But I'm conscious, to Lord Justice Zacaroli's point, the petition doesn't spell out prejudice in the form of, for example, being locked in. It doesn't say we are prejudiced because we're locked into a company with a wrongdoer. I would suggest that's quite often one sees petitions that don't spell out the prejudice specifically flowing from, for example, an exclusion or something of that nature. It's just something one can develop as the case evolves in submissions. But there it is. So just that's really looking at the pleadings and how the case was in fact firmly put forward. Turning to the substance of the matter, and before dealing with the very interesting questions of law that arise here, I just want to make good something that arose on the first day. And I took your lordships through some of the findings made by the judge. In particular is the finding that Mr Costa had misled the board. And some of the events described in the judge's exposition of the factual background lacked particularity. I think it's, with respect, fair to say. And so, for your lordship's assistance, we've sought to identify further particulars of the wrongdoing.
Of the misleading of the board.
Yes. And I first took you to various examples in the judgment concerning Mr Costa's treatment of Mr Loy when he made inquiries about the exit process. And I then provided your lordships with an example of his treatment of another director, Mr Flamini. And you may recall looking at an extract of an email. And we should go back to judgment. It's paragraph 55.
Are you drawing together here all the relevant paragraphs, maybe adding to what you dealt with yesterday?
Firstly, I'm going to clarify the particular points that have arisen where there's been a lack of particularity in the detail provided by the judge. Then we will refer you to our written closing submissions, which hopefully give you a little bit more understanding of the breadth of the case in respect of the misleading conduct. So your lordship's just got a better understanding of the, as I say, the breadth of the case. So paragraph 55. This is the email from Mr Flamini to Mr Costa on the 2nd of July. It's focused basically on the engagement letter. And Mr Flamini is complaining that he hasn't seen it. And then this is where Mr Costa responds by ostensibly reminding Mr Flamini of various things that have been apparently agreed by the board. And the judge finds in paragraph 56 that that's simply not the case, that they hadn't been agreed. And a confusion arose because, as Lord Justice Snowden pointed out, there's an inverted commas 2 lines down in the second paragraph, which might have been taken to suggest it was a direct quote from, for example, a board minute. That's not the case. We've checked the underlying letter, and those quotation marks do not appear in the original document, which we have handed up, should be before your lordships. They're a typo in the judgment, which regrettably was not picked up at the time the judgment was circulated in draft. So that's just Mr Costa speaking off his own bat, as it were. And then I took your lordships to paragraph 60 and his treatment of Mr Aspinall, who, another director, actually a member of the exit committee, and that's on page 191 of the bundle. And it was commented that the judge hadn't provided a date for this exchange that he refers to in paragraph 60. So we've pulled out the email exchange, and hopefully that should also be before the lordships. And you will see, if your lordships have that, you'll see that it's from the 17th of August. But if one just since you've got this material, it gives one a flavour of the tone which Mr Costa used in his correspondence with his fellow directors. Possibly better to start at the bottom. So we have on the 17th at 6:27 in the morning, Mr Aspinall asked for an update on progress. Can we have an exit committee meeting, please? I'm on holiday, but I'm getting pressure from his stakeholders, since we were expecting a conclusion by June this year, assuming Jeffreys must be doing something, but what? And then the response is, Steve, we are all on holidays. Jeffreys is doing the reach out. So important to note, Jeffreys, according to this, is now working. And this, of course, is before the CEO has actually been appointed. But Mr Costa is telling... he has been appointed, but he hasn't started work. That's not until September. And he says that'll be on the 1st of September. Mr Aspinall responds, holidays do not mean Jeffreys shouldn't be making progress. The lack of any progress concerns me. And the response is, who said we are not making progress? I met 12 potential investors so far. Now that was not a true comment. We see that from the judge's judgment at paragraph 58. Because the judge commenting on an exchange between Mr Minyard and Mr Costa about Metric's first exchange. Mr Costa had said, just tell them there are many parties interested and there will be a competitive bid. And then the judge found in 58 that wasn't true. So here that was on the 8th of August. And then here we have on the 17th of August, Mr Costa telling Mr Aspinall he's met 12 potential investors. So a similar, we would say, untruth. And then Mr Aspinall responds, great, show us. And goes won't be surprised to hear that there wasn't any revelation as to who these investors were. We are massively behind schedule. Let's see what's going on. We want action, a sale, not holidays and no info. And then Mr. Costa's response, Stephen, I'm very surprised by this email. Remember that I'm not your employee and I have nothing to show or demonstrate to anyone. The best independent financial company in USA has a mandate. If you want to be helpful, please introduce potential buyers. So it's a most unhelpful, uncooperative brush off to a fellow director who's quite fairly and legitimately seeking information about the process. He's told things that are untrue. He's not given any information. And so that's, and a member of the exit committee. Just to develop this point, one other set of materials which will assist you, Lordships, in our closing submissions. Again, it's back in the supplemental bundle, file 2. It's page 989. Now, again, these as my learned friend pointed out, they are extremely lengthy and detailed closing submissions. And in fact, it might be worth just looking at this. It starts on page 846, and one can see from the index the contents page at 847 and 848. We provided an extremely comprehensive review of all the evidence and the chronological narrative, and indeed our case, running to some 150 pages. But the relevant piece that we now show you is on page 989, and it's headed I3, the approval of the board. And paragraph 526, Mr. Costa alleges that the key decisions in the exit process were taken by the board. This does not assist him in circumstances where he repeatedly misled the board and ignored their instructions. By way of illustration. And then I'm not obviously going to take your Lordships through all of this now, but your Lordships will be able to see there are a number of sub-paragraphs which develop that part of the case. And the main point is that there was ample material, we say, on which the judge could conclude that Mr. Costa misled the board, and that was part of his conduct, his course of conduct in deliberately.
But the only, I mean, you can show us this, but the only ones that we can really pay any attention to, surely, are the ones that the judge actually found as a fact in your favour. I mean, because we're not able to sort of do this exercise of island hopping and make factual findings ourselves. It's which of these paragraphs, if any of these sub-paragraphs, actually are reflected in the judgment.
Well, my lord, unfortunately, the judgment is not specific. We have paragraph 208, which refers to the board being misled about the exit process. There's that reference in the consequential judgment as well, paragraph 41. I beg your pardon, I think it's judgment paragraph 202.
202 it is.
Yes, I'm so sorry. And there are the particular instances I did refer to a moment ago about paragraph.
And to pick up my point, just while we're en route in this, I mean, to pick up my Lord Justice Edis's point after lunch to you, there is another hint at maybe 10 lines up at the bottom of 248 of the judge's view as to what Mr. Costa knew about the company's obligations under 6.2, where he says Mr. Costa and Mr. Uboy were therefore the only people in a position to know both about the scope of Jeffrey's mandate and about the company's obligations under 6.2, and therefore to realise. I accept. I mean, he says they're the only people in a position to know. I mean, but he goes on in giving their fellow directors a different impression they misled the board. I mean, I think you'd say you've got to.
There's no doubt that Mr. Costa was fully aware of clauses 6.2. He knew what the clauses were. They were constantly drawn to his attention by other shareholders, and he knew what he was talking about when he was talking about the exit process.
But is that really these, as far as findings of fact go by the judge, is that really that couple of sentences, is that about misleading the board? Is that really it?
That's, I think, where he refers to misleading the board in the main judgment. Yes.
What, 202?
202. I mean, there are other instances. There's the slightly troubling exchange comment in paragraph 58. And we have paragraph 208, which I referred to a moment ago, which is where the judge seeks to finds that there's no breach of 172, but within that there is effectively a finding that he knew he was misleading the board, but it was better off that they didn't know for the time being because they'd thank him in the long run. It's not presented in a clear fashion, but in my submission that clearly does contain a finding that he knew he was misleading the board, albeit he considered it was for the best. So we've got 202, 208. There are references in the earlier narrative to him being misleading to individual directors. So we've got his treatment of Mr. Loy, we've got his treatment, we've got the slightly troubling exchange in paragraph 58, and we've got Mr. Aspinall and the material referred to in paragraph 60, and I've taken your lordships to the underlying emails. And we do, in the consequentials judgment, have a reiteration, albeit in general terms, of the judge's finding that Mr. Costa had misled the board, and that's paragraph 41.
You mentioned the paragraphs about Mr. Loy. Which were those? I think we've taken just before, but just I'm trying to put it all together here.
Yes. So the narrative with Mr. Loy is 49, 50, and 54. That I think is the key passage. Then we get into the Mr. Flamini and Mr. Aspinall. So there's a few pages there of background material which shows him, we say, misleading individual board members, certainly not being open with them as to what was going on. And we'll then do 225. So 225 towards the, page 255 of the bundle. Mr. Costa had sole control of the process relating to the company's compliance with its obligations under clause 6.2 and appears to have consistently reported to the board that these obligations were in fact being complied with when he knew they were not. Well, perhaps that is actually a rather clearer finding. In this regard, it is significant that his most strenuous efforts were directed towards ensuring that no other director had any information at all about the process other than what Mr. Costa chose to provide. I am therefore in no doubt that the company's failure to comply with its obligations was a direct result of the actions of Mr. Costa. So that perhaps is a somewhat clearer finding. And then he goes back to that in the consequentials at paragraph 43. So sorry for jumping around, but back to the consequential judgment, page 297 of the bundle. And you see 5 lines down. However, I have found that in practice, Mr. Costa had sole control of the process, and that the fact that the board acted as it did was the result of the fact that he had regularly misled it as to the actual state of disposal process.
Is this the judge dealing with an application for permission to appeal?
Yes.
Yeah, I just wonder why he's... Anyway.
Yes, it is, my lord.
Yes, I understand.
So, doing the best I can, that's the material we can accumulate. And I'll now turn to the legal analysis.
I mean, and to be fair to the judge, just having looked at your, as you invited us to, the start of your closing submissions, put the case very squarely as in the contractual box marked breach of Shareholders Agreement. I mean, that was undoubtedly the focus of the way the case was put to the judge and where he was spent most of his effort.
My lord, I don't dispute that as a matter of emphasis. I mean, there's no doubt the other part of the case was advanced as well, but clearly the shareholders' agreement and compliance therewith was a substantial focus of the effort. So moving on to the legal analysis, and your lordships might as well have it before you, paragraph 208 on page 250. You've seen this a number of times. But in short, having found that Mr Costa deliberately caused the company to breach clause 6.2, acting in his own personal interests, and knowing that this was contrary to the wishes of some of the other investors, he misled the board about what he was doing. The judge nonetheless held that this was not a breach of section 172. And he did so on the basis of his finding, encapsulated in the phrase, "They wouldn't like it now if they knew, but they will thank me in the long run," that Mr Costa believed that his actions were in the best interests of the company. And in my submissions on Tuesday, I made the following two main points. Firstly, this case that to the effect that Mr Costa had deliberately misled the board on the basis that the ends justified the means was not Mr Costa's own case. It was a theory developed by the judge and the judge alone. Secondly, and possibly, and certainly more relevantly for what I'm going to go on to talk about, the nature of the conduct, deliberately breaching an agreement between all the shareholders in the company and then misleading the board about that, simply could not be squared with compliance with section 172 as a matter of law. And following the discussion yesterday and carried on this morning, I'm going to develop our submissions on that second point. Where my learned friend has ended up, as I understand it, is that section 172 is purely subjective, in that provided the director actually believes that what he is doing is in the best interests of the company, then there can be no breach. And I use the word actually believes deliberately because it seems, in my submission, to be a clearer way of expressing the point than words such as genuinely or sincerely. And I'll develop this, but I suggest that those words, genuinely or sincerely, don't add anything.
Nor does any word, does it? You either believe or you don't.
My lord, you've made my point for me. But I say yes, the same goes for good faith. Ultimately, it's a question, if the good faith is directed to the belief, either, it's a question of fact, either the individual actually believed it or he or she didn't. And adding genuinely or sincerely or in good faith to that specific point is just rhetorical flourish. It doesn't add anything of substance. It's a question of whether or not something was actually believed. And so the problem with my learned friend's approach, and it's a problem familiar to all students of company law, is that it leaves the way open for a person whose moral compass, say, is somewhat out of the normal, to carry on in a way that to ordinary people would be clearly unacceptable. Because provided this unusual person believes that what they are doing is for the best, they are never going to be in breach of 172. And what is usually said in response to this is that, well, you can rely upon the judges to disbelieve that person. Or put differently, you can rely upon the judge to do the right thing and find that the position taken by this unusual person is just not credible.
But what if they're telling the truth?
Exactly, my lord. That's not actually a satisfactory answer to the point of principle. And indeed, it doesn't apply in the present case, because here we have a judge who has found that someone who we say is plainly done things that cannot be squared with honest norms, has found that they genuinely believed they were doing the right thing, or acting for the best, rather. So this case does present the point rather neatly. And it's here that I will gratefully pick up the ball that Lord Justice Snowden has deposited at my feet and seek to run with it, if I may, because I respectfully suggest that the answer does lie in the approach to be taken to the good faith element of the 172 duty. I'll go to some authority in a moment, but in short, I suggest the analysis is as follows. Directors are fiduciaries. Fiduciaries owe a duty to act honestly towards their principal. Honesty is governed by objective norms. You can't set your own standards of honesty. That element of honesty in the context of directors was captured under the common law pre-2006 by the formulation that a director must act in good faith in what they consider to be the best interests of the company. The idea that that fundamental duty has been abandoned with the codification of that duty under Section 172 is not tenable. Indeed, the argument, as I understand it, seems to rest on no more than the positioning of the words good faith in the first sentence of Section 172. But I suggest that it doesn't matter that they come after the word considers. And to elaborate, and again, it probably makes sense for us to have the provision in front of us, even though it's obviously very familiar. So it's page 9 of the authorities. If the argument is that the words good faith, because of where it comes in the sentence, is only supposed to operate on the word considers, one must ask, how does it so operate? What does it do to the word considers? What does it add, if that's supposed to be its purpose? And the answer is it adds nothing.
That was your point earlier.
It was.
You either consider or you don't.
Exactly.
Which is what I think Lord Justice Zacaroli just said.
Indeed.
In fact, in just the same way, if you simply delete the words in good faith, you get to the position advocated by Lord Wolfson.
Indeed. Yeah.
So you can't just delete the words in good faith, you have to give them some meaning.
And that meaning can't simply be operating on the word considers, because that doesn't give it actually any effective meaning. Considers in
You either consider or you don't.
Exactly. Considers in good faith. For myself, I don't really know what that means. So on this analysis, on his analysis, the words good faith add nothing. And if his case is to be accepted, their positioning in the sentence has dramatic impact in terms of abandoning centuries of accepted wisdom regarding what the fundamental duty of a director should be, namely to act honestly. The correct analysis, of course, is that the words good faith in Section 172 do what those words always used to do in the formulation of the duty, and they require that the director must act honestly. So in the result, the duty remains fundamentally subjective in that a director actually considers, well, if a director actually considers that what they are doing is for the best interests of the company, then normally there will be no breach. But this is subject to the requirement to behave in good faith. And that requirement imposes minimum standards of honesty. Effectively, it provides some guardrails within which the directors have a right to roam. Now, I'll turn to the authorities, but in my submission, this is perfectly consistent with the authorities. It's noticeable that this particular analysis hasn't been fleshed out or explicitly stated, as far as I'm aware, in any authority. And that probably is because ordinarily a director adopting a position that they genuinely believed that they were doing the right thing, notwithstanding that it's dishonest, will either not be believed or they just won't be running that case. So it's an unusual situation, but it does arise here. Now, my learned friend, during the course of his submissions, said that the duty of a director under Section 172 was different. He has to say, I think, that it's different from the old common law duty. But I will come to Smith and Fawcett because he did make a point on that before. But I'll just try and make the point that there clearly was no intention to change the law in this respect by reference to one authority, which is the Premier Waste Management case, which I hope is before your lordships. Now, don't think we need to look at the facts, but it's the Court of Appeal 2011, Lord Justice Mummery, and happily starts his judgment with legal background, and your lordships will just see there that there's some general comments about the fiduciary status of a director. And then paragraph 3, really, I've described the equitable principles and duties in the past tense because under codification measures in Chapter 2 of the Companies Act 2006, the director's general duties to the company are now statutory. The codified duties are expressly derived from common law rules and equitable principles as they apply to directors. The relevant events in this litigation occurred in 2003, well before those provisions of the 2006 Act were brought into force. Although the pre-2006 Act common law rules and equitable principles continue to apply to a pre-2006 Act case, it is unrealistic to ignore the terms in which the general statutory duties have been framed for post-2006 Act cases. They extract and express the essence of the rules and principles which they have replaced. Section 170 sub 3 provides that those general duties have effect in place of those rules and principles as regards the duties owed to a company by a director. That did not consign the replaced rules and principles to legal history, because Section 170 sub 4 provides that the general duties shall be interpreted and applied in the same way as common law rules or equitable principles, and regard shall be had to the corresponding common law rules and equitable principles in interpreting and applying the general duties. So Lord Justice Mummery was certainly of the view that even though he was dealing with facts that predated the 2006 Act, it was perfectly appropriate to have regard to the principles under the 2006 Act for the simple reason that they were reflective of the old common law rules. So that case provides a clear example of the relationship between the codified duties and their equitable and common law forebears. So in interpreting Section 172 sub 1, one necessarily looks at the cases concerning the content and ambit of the fiduciary duty which it replaced. We are to have regard to the common law and equitable principles. And obviously one immediately thinks of Smith and Fawcett as the locus classicus of this particular duty. And my learned friend took us this morning. I hope your lordship still have it. And I just want to take you to one passage which my learned friend sought to rely upon towards the end of the judgment. So page 308, and helpfully highlighted by my learned friend. And in fact, not only highlighted, but underlined. We have a sentence as follows. The question, therefore, simply is whether, on the true construction of the particular article, the directors are limited by anything except their bona fide view as to the interests of the company. Now, my learned friend stopped there, as if that was both the question and the answer. But in fact, the Master of Rolls went on to give the answer. And if you read on, he says, In the present case, the article is drafted in the widest possible terms, and I decline to write into that clear language any limitation other than a limitation which is implicit by law that a fiduciary power of this kind must be exercised bona fide in the interests of the company. So, insofar as my learned friend was seeking to rely upon the red underlining sentence as supporting the proposition that bona fide only operates on the consideration, that's clearly not the case. In fact, this passage reinforces the point that bona fide has a freestanding role in the context of this fundamental duty. The Master of Roles answers his own question, and he answers it very much in line with what I've just said. Then we should look at Regent Crest, which is Volume 1 of the Authorities Bundle, tab 15. And we did spend some time on this with my learned friend. It's page 309 is the relevant passage.
Just to be clear, I think what Regent Crest is doing, or is really dealing with, is the question that if somebody had stopped Lord Green and said to him, when you say must be exercised bona fide in the interest of the company, who decides what the interests of the company are for this purpose? Is it the director or is it the court? And that's the question that was really at issue in Regent's Crest.
My Lord, I'm grateful for that.
Thanks.
Yes. And the relevant passage is at page 309. And as my Lord Justice Snowden said, we have paragraph 120, where there's some restatement of the well-established formulation in the first sentence. And then paragraph 121, we do have the reference to Lord Green, Innsmouth and Fawcett. And then Mr Justice Jonathan Parker goes on to cite the well-known statement of the duties of a fiduciary given by Lord Justice Millett in Bristol and Western Mothew. The various obligations of a fiduciary merely reflect different aspects of his core duties of loyalty and fidelity. So there are various obligations of a fiduciary, and they are reflective of his core duties of loyalty and fidelity. The point being made there is that the director's duty to act in good faith is an aspect of, or one might say is another way of expressing the core duty of loyalty and fidelity owed by a fiduciary. And so the thesis is that the core duty of loyalty and fidelity to the company is not discharged by the director merely acting in what he subjectively believed was the best interest of the company. We say that the duty of loyalty contains within it an obligation to act honestly. And we say that follows from the formulation of Lord Green, which I've taken you to, and which he actually, in the passage I did identified as him answering his own question, he makes absolutely clear. And it also is apparent from the way in which Mr Justice Jonathan Parker describes the duty in paragraph 120 in the first sentence. Now, to the extent there's any doubt about honesty forming part of the core duty of fidelity and loyalty, we've got another more recent case. It's a decision of Lord Justice Leggett, as he then was, in Al Nahyan and Kent. And hopefully you have that. Now, in this case, it was alleged by the defendant as part of his counterclaim that the claimant owed to him fiduciary duties arising out of a joint venture. So it's fiduciary duties in the context of a joint venture that we're concerned with. And the material part of the judgment starts at paragraph 153 on page 264 of the judgment. And apologies, we've not marked this up. But you can see there, paragraph 153, headed fiduciary duties. So on behalf of Mr Kent, Mr Lewis submitted that even if they were not in partnership, Sheikh, Tanoon and JK engaged in a joint venture in which they owed each other fiduciary duties. And then if, my lords, you turn to paragraph 156, you see further reference to the submissions of Mr Lewis. So between letters B and C, Mr Lewis submitted that these facts gave rise to fiduciary duties on each party to act in good faith, not to place himself in a position where duty and personal interest might conflict, not to make any personal profit from the joint venture other than that agreed with the other, not to make a personal profit from the trust reposed, and not to abuse the trust reposed. Paragraph 157, in considering this submission, I bear in mind that it is exceptional for fiduciary duties to arise other than in certain settled categories of relationship. The paradigm case of a fiduciary relationship is, of course, between trustee and the beneficiary of a trust. Other settled categories of fiduciary include partners, company directors, solicitors and agents. And then just moving down to paragraph 158, Lord Justice Leggett, as he then was, goes on to explain the nature of a fiduciary and the obligations owed by one. And your lordships can read paragraph 158. And then paragraph 159. Again, there's further analysis of when the fiduciary duties arise, but if we just get to letter C, you see the essential idea is that a person in such a position is not permitted to use their position for their own private advantage, but is required to act unselfishly in what they perceive to be the best interests of their principal. This is the core of the obligation of loyalty, and again, that's reminiscent of the language used by Mr Justice Jonathan Parker, the core of the obligation of loyalty. Described as the distinguishing obligation of a fiduciary. And this is the important section. Loyalty in this context means being guided solely by the interests of the principal and not by any consideration of the fiduciary's own interests. To promote such decision-making, fiduciaries are required to act openly and honestly and must not, without the informed consent of their principal, place themselves in a position where their own interests or their duty to another party may conflict with their duty to pursue the interests of their principal. So there's a clear statement explaining that the connection between the duty to act honestly and the core duty of a fiduciary. So as I mentioned before, I would highlight that the duty to act in what a fiduciary perceives to be the best interests of the principal is the core of the obligation of loyalty. We see that from Regent Crest and Bristol and West. And the second point is that by reason of that obligation of loyalty, fiduciaries are required to act openly and honestly. And in my submission, that shouldn't be a remotely surprising or odd proposition. It is entirely a common sense matter. And indeed, it follows, as an equally common sense matter, that it cannot make any sense to construe the obligation to act openly and honestly as a subjective duty. The duty is clearly to be assessed by reference to an objective standard. So on that basis, we say, I go back to my point that 172 is a subjective duty in that it fundamentally a director, provided they actually consider that what they are doing is in the interest of the company, that essentially means they are complying with the duty. But there is a good faith component expressed in 172 reflecting the previous common law that brings with it an objective standard of honesty, which operates, as I said before, my analogy would be guardrails to ensure that the basic norms of honesty are respected, or rather can't be abused by someone whose personal beliefs are thoroughly beyond the pale. Now, once one appreciates that Mr Costa was under a duty to act openly and honestly, it necessarily follows that he breached that duty when he misled the board. Even if, and we don't accept this, he actually thought that the ends justified the means. So on that basis, we do.
Well, you might not accept it, but the judge seems to have found that.
My lord, that is a finding. Yes, indeed, that is his finding, absolutely.
So
we have to accept it for present purposes.
Yeah.
Yeah. But in a sense, that is perfectly consistent with him being in breach of duty as far as we analyse 172.
Now, if we have a 5-minute break this afternoon, will we finish at some reasonable time?
Yes, I imagine if I can go to past, that will complete my submissions. I think we potentially were allowed maybe 5 or 10 minutes additional at the end, and that might be sufficient to make us equal.
I'm not going to fall out with my learned friend over 5 minutes, or I hope I'm not on anything else. If we go to half past, my lord, and take a short break, I hope very much I'll be able to finish by 4:30. It depends obviously on the number of questions, but I would certainly hope to.
Thank you. Well, in that case, shall we take our break in a few minutes' time then?
Well, perhaps now would be
All
a
right,
convenient moment because I have
since we've
finished
stopped
that.
Anyway. Yes, okay, 5 minutes.
All right.
Was that what it was? What did you think you might say? short of a few people. I don't think they've given up, but...
No, almost certainly not, but my watch may be running a little fast.
Okay, knock the door.
I think someone's just going.
So I do apologise.
No, please don't worry at all.
I'm going to move on to grounds collectively 3, 4 and 6, which deal broadly with prejudice / relief. I don't have much to say in reply, but one of the questions raised by Lord Justice Edis was whether the judge had dealt with our case, that the obligation on the shareholders under clause 6.3 of the Shareholders Agreement to procure that an exit is achieved in accordance with the proposal, whether that applied in the period prior to the 31st of December, as well as after. And I confirmed that the judge had not dealt with that part of our case in his judgment, and then we had we've just gone back to the pleadings, and whilst the point was overlooked by the judge, it was certainly part of our case. And I'll just make that good. If Lordships could take the petition, please. And at page 305, that's where the petition starts. And if Lordships turn to paragraph 9 on page 307, there's reference there to the shareholder agreement. And then paragraph 12 on page 300. Paragraph 12, you see reference to clause 6.2. And that identifies the fact there were 2 phases. Then paragraph 13, this is the point, at both stages, on the true construction of clause 6.3 of the shareholders agreement, each shareholder was obliged, etc. So the pleading is clear that it's applying clause 6.3 in respect of both stages. And then if one goes on to paragraph 62 sub 1 on page 327, that refers to clause 6.2. And that says that, contrary to the position adopted by Mr Costa at the meeting on the 3rd of December, it was not open to the shareholders to postpone an exit until the conditions for sale were more favourable, save by amending the shareholders agreement. That's another point that was squarely put in the petition. In terms of our submissions to the court, again, our written closing submissions are at page, if we could go to those please, it's back in the supplementary bundle, volume 2. And page 849. So right at the beginning of the submissions, we have a section headed the key elements of the case on unfair prejudice. And if I may do so, I would commend this section to Lordships as a helpful summary of our case. But given the time, I won't go through it all, but you will see references to clause 6.3, including in paragraph 2.3. So if and when terms for sale were proposed in accordance with clause 6.2, the investors were obliged to cooperate and assist in connection with the proposed sale and to procure that the sale was achieved in accordance with such proposal. This is the obligation under clause 6.3. Similarly, we see in paragraph 4, reference to
2.3 is, it's not clear which phase you're addressing there. It's just the second phase, isn't it? I mean, it's not clear because you've got 2.1 is the first phase, 2.2 is the second phase, and then you sort of just...
Yes, it's both phases. I mean, what I'm trying to develop here is the point that we did make the case to the judge that 6.3 applied both before and after the end of the year.
Yeah, I know what you're trying to do. I'm just saying, I'm not sure that 2.3 is quite as clear as that.
My lord, I do appreciate that it doesn't spell out that it's second or first phase.
Yeah, no, okay.
And then 4, in the result that no terms for an exit were ever proposed. And then in that case, you'd never get to 6.3 because, and this was the problem, of course, no offer was ever proposed. So the entitlements and the rights under 6.3 never, the rights and obligations under 6.3 never came in. But one might inferentially read 4 as including both before and after. And then paragraph 7.5. This is perhaps a clearer answer to your Lordship's concern. If the best available terms for an exit had been proposed to investors prior to the year end and or in the first months of 2020, as they should have been, the investors would have been subject to the obligations under clause 6.3. So I think that's rather clearer in saying that we did say that the provision applied before as well as after. So we say that once the meaning and effect of terms of clause 6.2 and 6.3 is appreciated, it's clear that it's not a fair and adequate response to the unfair prejudice that Saxon Woods has suffered, that it should only be entitled to a buyout and an exit if it can prove that the best offer that the company would have obtained would have exceeded $75 million. The premise of that conditionality is that the shareholders would have had a free hand to reject the offer, and that an offer that was not in excess of 75 million would have been so rejected. Hence the requirement to construct a counterfactual world to test that question. But as I explained previously, the premise is wrong. The shareholder investors did not have a free hand at all. They were under obligations, both under clause 6.2 and 6.3. And indeed, if you got into 6.3, the sale had to be completed within a reasonably short period of time. The effect of those obligations is that one can be satisfied, certainly on the balance of probabilities, that if one or more offers had been obtained, as they would have been and should have been, a sale would have been achieved. And on that basis, Saxon Woods would have realised its shares for value. And it makes no sense, and I would suggest it's unfair, to require Saxon Woods as a condition of obtaining a buyout to have to prove at a separate causation trial that a particular value would have been achieved, failing which Saxon Woods will obtain no relief at all. As I mentioned before, the judge said it was difficult to imagine a clearer case justifying a buyout, and the only thing stopping him making that order was his concern that Saxon Woods might not have suffered any financial loss. But on the analysis, the correct analysis of these clauses, as I say, the court absolutely can be satisfied and balanced probabilities that loss has been suffered because a sale should and would have taken place. So once the prejudice flowing from that is understood, it's clear that an unconditional order should have been made. My Lords, that completes my submissions on prejudice and relief. As regards ground 5, which concerns what we say is the lack of proper basis for the identification of $75 million as the threshold, I refer your Lordships to our skeleton, paragraph 60 to 65, page 40 of the C bundle. I'm not going to repeat those submissions. The key point we do make here is that really there was no adequate evidential basis for any particular number. The judge alighted upon $75 million, we say in a somewhat surprising way, relying on a rather oblique email from Mr. Uberoy. But as was apparent from my learned friend's submissions this morning, there were lots of different figures bandied about, referred to at trial, but there was no orderly examination or inquiry at trial into what the number might have been, for the simple reason that that was not part of either party's case, that a particular number would have been required in order for a sale to have been achieved. That just leaves costs. And this is ground 7 of our appeal. In opening, I essentially referred your Lordships to my skeleton argument, and I'm not proposing to do much more than that at this point. But I would make the following points. the reason why the judge reserved costs was entirely down to his view that financial loss needed to be shown, and hence the need for the conditional buyout. Since that is, on our case, misconceived, and had the judge appreciated the correct position, in my submission, he would clearly have made an order for costs at the end of the liability trial. After all, he did make a clear finding of unfair prejudice. So once one sweeps away the misconception that led him down the wrong road to the conditional quantum trial, there's no impediment to the idea that the normal costs costs in the event would have followed the liability trial. Now, my learned friends refer to the Ashdown and Griffin case as a case where what happened at the quantum trial was that the shares came back as a nil valuation. And indeed, it had been apparent even at the liability trial that this company, the company in that case, was likely to be worth next to nothing. And there's even a comment by the judge at the liability trial to the effect, and this is not precise words, but to the effect that, do you really want to go ahead with your quantum trial? And when the quantum trial came back with a nil valuation, in those circumstances, it's perhaps not surprising that the costs position was effectively reversed, notwithstanding the finding of unfair prejudice. Our case is very different. On any basis, if there's an unconditional order for a buyout, these shares will be worth a considerable amount of money. So we're not in the Ashdown and Griffin type of situation. What we are in the situation of is a discrete liability trial will have been determined very, very clearly, a great deal of time and cost having been spent on arguing issues of liability, and Saxon Woods will have been the clear winner. So absolutely, in that case, if we win in our appeal and persuade your lordships that it should be an unconditional buyout, certainly the costs order should be reversed. But we also say that even if we fail on that front, and your lordships are content with the quantum trial as directed by the judge, it's still the case that the order that the judge made following the liability trial on costs was wrong. The liability trial was concerned with the question of whether there had been unfair prejudice. Now, I say it again, the judge did find there has been unfair prejudice. One can debate quite what he meant when he said prejudice, but he was certainly put under pressure to clarify his position, and he did by doubling down and saying, yes, there's been unfair prejudice. Moreover, that trial was a hard-fought trial on all issues of liability concerning Mr Costa's conduct over the period of a year at least, and indeed back into the history of the thing, as to his conduct of the exit process and his dealings with the board, etc. And Saxon Woods essentially prevailed on those essential issues going to liability. The only question that was outstanding was this question of financial loss. So having fought tooth and nail on the, if you like, the substance of the allegations, and Saxon Woods having won on those issues, we say that the correct order would have been that we have our costs of the hearing, even if there's to be a conditionality around the prospects of us getting a buyout.
But if in a normal contract claim for breach of contract where loss of an opportunity is relevant as a matter of causation, if that were the approach, which I think you accept is really what has underpinned the judge's judgment, in a case such as that, if you have a claim for breach of contract and it is said, yes, there's a breach of contract, yes, you lost the opportunity, but the opportunity was worth nothing, then you would probably end up paying the costs.
Well, my lord, I can see that if one approaches the question of costs through a sort of analytical appraisal of the cause of action and the significance of particular aspects and whether or not possibly one has been left over or one hasn't won on it, you can reach that kind of conclusion. But in my submission, the costs jurisdiction should be dealt with in a rather more sort of pragmatic fashion, having regard to what the money has actually been spent on and who has won on those issues, at least in broad terms. And in this case, it would have been open to Mr Costa to say, well, I accept that you may be entitled to a buyout, subject to one, because I behaved badly. I didn't run the exit process, I accept that. But actually, my view is you won't get a buyout if you can't show that an acceptable offer wouldn't have come along. And so we need to have that issue determined, in which case the only thing that would have happened would have been the causation trial, effectively. And all of the I can't remember how long it was, 4 weeks spent cross-examining Mr Costa about what he did in the exit process to establish his breaches of duty, or rather causing the company to breach clause 6.1 in particular. None of that need have happened. And if he'd, as I say, done what we say he could have done and said, fair enough, I didn't behave properly, I did this for my own interest, my gamble did not pay off, I accept there have to be consequences of that if you can show you've suffered loss. That, in my submission, would have been a sensible and reasonable thing to do, perfectly open to him, and he didn't do it. Instead, we've had a 4-week trial, which we have effectively won, subject to a caveat. So, my Lord, on that basis, we do say that the cost order is wrong, even if we fail on our appeal. My Lords, grateful for you allowing me longer again than I asked for. If there's anything else I can assist you with. Thank you.
No, thank you very much, Mr Davis.
My Lords, I hope I can say that in this case, when I made my opening submissions, we had rather perhaps more interaction between myself and the court that sometimes we have. That means I think I can make my reply submissions shorter, because some of the points, again, when it came to learned friend submissions, some of the points which were put to him by the court are points which I would otherwise have made. The battleground is now pretty well trodden. There may be some points still of unexploded ordnance, which I'll try not to set off in the next few minutes. But subject to that, I'll try to keep these points short and focused. On ground one of my appeal, just to be clear, obviously, formally I can only reply on my appeal, subject to the point I made earlier. On ground one of my appeal, the central point I would want to emphasise in reply is that my learned friend, as I'm sure the court appreciates, mischaracterised my approach to the first sentence. It was never part of my approach to the construction of the first sentence of 6.2 that all it is a definition. I think I repeatedly said the point is it's a definition and an obligation. And therefore, I think towards the start of the learned friend submissions, he sought to set up somewhat of a straw man by saying, well, I'm saying that first sentence is only a definition, second sentence is an obligation. That has to be wrong. It is wrong, but it isn't what I was saying either. And I'm not going to repeat where I took that argument, but of course, that was the genesis of my submission, that the words at the end of the first sentence do not bear the meaning that they would otherwise bear, as I frankly accepted, if that first sentence wasn't also a definition, because the draftsperson is trying to do two things at once. That's the first point on ground one. Second point on ground one is that my learned friend said that if our construction is right, even if our construction is right, we're still in breach. He listed various factual findings which he said supported that proposition, but he didn't focus on the most important factual finding of the learned judge in this context, which is the finding at 183 of the judgment, which in terms is that Mr Costa was pursuing an exit. And therefore, if the court is with me, on my construction of the first sentence of ground one. In my respectful submission, taking the judgment as a whole would mean that we are not in breach of that obligation. I think to say anything else on ground one would probably trespass from reply into restating my position.
The only question requires a binary answer. It was put that you're not pursuing the other grounds or other arguments in your skeleton on construction, and it was assumed that you're not pursuing those. Is that right?
Well, I'm not pursuing them in the sense that, just to be clear, I'm not saying obviously that they're wrong. I say they're right. Realistically, however, the propositions there set out are not going to get me home unless I'm correct on what I've submitted orally. And that's why I hope realistically, right at the start of my oral submissions, I said that I was going to focus on the points which I really need, so to speak, to get me home. That's what I've sought to do. I hope that's a realistic way of presenting the matter. Ground two, my lords. On ground two, I think the only point, again, I need to reply to, as opposed to repeating other submissions, is that my learned friend really doubled down, if I can put it that way, on what we were calling the subjective question. My lords will recall there's the first question as to whether metric is an exit as defined, and then there's the subjective question as identified by the judge as to does it make a difference if we didn't appreciate that at the time. And we do respectfully submit that the answer is really straightforward on basic contractual principles. You might not know the whole story at the time. In other words, when the metric expression of interest comes in, you may not know whether in fact it is going to be, or indeed is, an exit capital E or an exit small e. It's therefore for the director to take a decision as to whether or not to consider the offer. But that's a separate question as to whether ultimately the company is in fact and in law in breach of contract. Of course, by not considering the offer at a time when you don't know whether it's exit capital E or exit small e, the director is taking something of a contractual gamble. But if it turns out that it wasn't a capital E exit, and your contractual obligation is only to consider opportunities for a capital E exit, then it turns out that you're not in breach. You may be lucky, so to speak. You may be saved by the contractual bell. But in my respectful submission, you're not in breach of contract. And that's because the contract requires you only to consider opportunities for an exit capital E, not any offer that comes in.
But how? It can't be that binary, surely. If you've got somebody who's interested, who hasn't just said, here's the contract, take it or leave it, but they say, we are interested, we've got lots of people, we've got lots of funds, or we've got a fund with lots of money, we invest in all sorts of things, we are interested in buying 100% of this company, but it doesn't say what the terms are. You've got an opportunity to go back and say, haven't you, oh, that's great, but we're only prepared to sell if it's an exit capital E. And they may come back and say, oh, that's all right, we can accommodate that. Or they may come back and say, well, we prefer an exit small e, and then you say a bit more negotiation, whatever. But if you don't even start that ball rolling, you never get the chance to find out whether there's an exit big E at the end of the day, because you have not pursued an opportunity.
So, my lord,
I think that's the way it's put against you. I mean, unless I've got it wrong.
I absolutely see that, and I do. My first sort of the way I hang my hat is to say, if in fact, as we now know, it wasn't an exit capital E, you are saved by the contractual bell. That's my first answer. The second answer is, if you are in breach by not considering an opportunity for an exit and reading an opportunity for an exit include something which did not in fact turn out to be an exit, capital E, although you may be in breach, certainly no loss flows from it in circumstances where we now know it wouldn't have matured into an exit capital E. That's another way of getting to it. It's my less preferred route, but it is another answer to the question.
And remind me why we definitely know it wouldn't have been an exit capital E?
Well, that brings me to my proposition that the metric EOI is not an exit, capital E.
Okay.
Which is a point I've made submissions on. I wasn't going to.
Right. Okay. So
Yeah.
it's just that yes. Okay.
Yes. Yeah. I mean, it's necessarily wrapped up with that point. Yeah. I mean, if I'm wrong that metric it was an exit capital E, then not considering the metric proposal was not going to be considering a proposal which could have become an exit. It didn't get beyond, of course, a conditional offer. There was no binding offer ever made from metric. But that takes us back into the point.
So is there more than the two letters we were shown by Mr Davis in terms of the metric offer, whatever that was?
There is.
There is a third letter
It's got no.
in 2020.
Yes. Yeah. There is.
My lord, if it assists, it's tab 22, page 32, page 438 of the supplementary bundle.
Thanks.
I'm grateful. So the question as to metric, whether metric was or was not an exit, is obviously linked into this to this point we're now on. On that point, there was a suggestion that it was entirely speculative whether there would or would not have been what I've been calling a rollover in as part of the metric proposal. And with respect to the learned friend, the judgment goes beyond the passages he was relying on in that context. At judgment 185, we have seen this. It's the second half of that paragraph. The learned judge says that it's uncontroversial that a sale to metric or any other of the PE houses which existed on Jeffrey's list of potential investors would have been effected through 100% purchase by an SPV, and in those circumstances it would have been, quotes, highly likely, quotes, that there would have been some rollover. So what the judge is finding is that when you're dealing with a PE house, it's highly likely that there would be a rollover. So it's not right to say that it was highly speculative at that stage as to whether there would be a rollover or not. On ground 3, I'm not sure there's really anything I need to say in response to ground 3, because Malone Fenn's submissions on ground 3 really flowed very substantially from his submissions on grounds 1 and 2. On ground 4, my Lord Justice Edis referred to paragraph 208 of the learned judge's judgment and questioned whether this meant that the judge, whether the judge had held that Mr Costa knew that what he was doing was in breach of contract. And my Lord Justice Snowden made a similar point in relation to the judgment of paragraph 202. With respect, I would not read either paragraph in that way. I accept there is some potential ambiguity, but they have to be read in the context of the very clear finding at 200, which we looked at. I think I discussed this in an exchange with my Lord Justice Zacaroli, that the learned judge finds at 200 that Mr Costa knew or should have known. Now, that necessarily means, as I said before, that there is no holding, there cannot be a holding, that he knew. Otherwise, or should have known is entirely redundant and indeed inconsistent. By the time one gets later in the judgment to 208, the learned judge has made his findings on the construction of the contract. So what I submit he's doing in 208 is paraphrasing. Essentially, Mr Costa took the view that it was the best interests of the company to do something which, the judge has found, was a breach of contract. That is the way, in my respectful submission, one ought to read 208. And it's the only way to make 208 consistent with the point made at the end of 200. My Lords, that is what I was going to reply to on my appeals. I did put down a marker to ask whether the court would allow me to say a word on the 172 point in light of the new authorities, and I hope I'm not trespassing on the court's patience if I do that. I see the time. We will certainly finish before 4:30, and I hope well before that. So, if I have the court's permission to do that, I'll continue.
Well, yes, as far as I'm concerned, that would be very helpful, Lord Wilson, but we do have to finish at 4:30.
Absolutely. I'm sure we will, my lords. So just a few points on 172, and particularly arising from the presentation by my learned friend and his submissions also on those two new cases. Just one point to make at the outset. Before coming to the legal points, my learned friend referred a couple of times to Mr Costa misleading the board in pursuit of his own personal interests. Now, just to be clear, that is not what the learned judge found. The learned judge did find that Mr Costa misled the board. I said first time I spoke in this case, I wasn't seeking to avoid any of the factual findings, and I'm not. But he found that the misleading by Mr Costa was for the purpose of what Mr Costa believed was the company's best interest. And that's important, my lords, obviously, when you get to considering not only is there a breach of 172, but what ought to follow from that breach of 172. There's a difference when you say, I'm going to fib to somebody or act in a nefarious manner to feather my own nest. It's quite a different thing when you say, I'm going to fib to them to feather the company's nest or to feather their nest. It's quite a different, certainly when it comes to, we would say duty, but also certainly when it comes to remedy. Now, as to what the words in good faith add in section 172, having looked at the new cases as well, I do respectfully stand by the submissions I made before my learned friend relied on those authorities. I have 2 points. First, all of the old authorities, if I can call them that, talk about good faith, bona fides, honest or genuine beliefs, or the like. Had the words, therefore, good faith, been left out of section 172, it's that would have been no doubt interpreted as having some significance, suggesting the test really had changed in a critical way. And the words are there, second point, because it is an entirely subjective test. My learned friend, again, sort of threw down the gauntlet and said, my case is that the test is entirely subjective. That is my case. And I set out the authorities on which I rely. Absolutely, that is my case. And whereas in other circumstances, it might be enough simply to say in what the director considers and leave it there, on the basis that, as my Lord Justice Zacaroli said, you either consider it or you don't. The purpose here, and in the statute, in the context of the previous authorities, is to stress the importance that you really have to believe it. You have to believe it, so to speak, in your heart of hearts. We're all capable of kidding ourselves. Section 172 makes it clear that this has to be a genuinely held belief. And I accept what I've just said. You could take out genuinely held and say it's the same thing. But people talk about genuinely held beliefs. The cases talk about genuinely held belief. The judge here talks about a belief sincerely held. It's the way people, especially if I may say lawyers, talk about these things. And that's why the words are in the statute. If I can therefore say a word about Smith and Fawcett and a word about Al-Nahyan. On Smith and Fawcett, we do respectfully submit that my learned friend's reading of the passage he relies on is incorrect. On page 308, I'm now on. I highlighted and underlined, that's the extent of my electronic ability, both of those sentences, because in my respectful submission, they say the same thing. What's happening in that highlighted passage is the learned master of the rolls is asking the question whether, looking at the true construction of the article, the directors are limited by anything except what? Except their bona fide view as to the interests of the company. And I made my submissions on that. The learned friend then says, yes, but he pulls back from that later in the paragraph. With respect, he doesn't. What he's saying is, I decline to write into that clear language, i.e. the language in the articles, any limitation other than a limitation which is implicit by law, that a fiduciary power, etc. That is the same limitation as he said earlier, the directors are limited by anything except. He's repeating the same thing. His formulation, when the learned master of the roll says a fiduciary power of this kind must be exercised bona fide in the interest of the company, which, as my Lord Justice Snowden, that was essentially the point he makes, the way he phrased it at the beginning of the judgment. In my respectful submission, that is in his mind the same thing as and means their bona fide view as to the interests of the company. So that is, in other words, it's not a question and a different answer. It's a question which contains within it a proposed answer, and then the answer is yes, that's right. That is my submission as to the proper reading of that highlighted passage on 308. As to Al-Nahayan, which is a decision that's the one that was handed up this afternoon, the relevant section of Al-Nahayan is page 100, paragraph 159 on page 267. It's important, with respect, to read this carefully. I'm just going to say something really for, if I may say, the court's note, not because I'm suggesting that this detracts from, this means the passage doesn't require a proper analysis. In fact, Lord Justice Leggett, as he then was, found that there was no fiduciary duties here. So very strictly, it's obiter. I appreciate who the judgment is from. I'm just pointing that out just for the benefit of the court's judgment. I wouldn't want it thought I'm trying to, so to speak, dodge what the learned Lord Justice said. I'm certainly not. The point he's making, however, in my respectful submission between C and E, is picking it up after the reference to Professor Smith's seminal article, which I'm sure everybody has read on several occasions. The essential idea is that a person in such a position can't use a position for their own private advantage, but has to act unselfishly in what they perceive to be in the best interest of the principal. Now, just pausing there, that statement focuses on two things. One, loyalty. Two, a subjective perception as to what the best interests of the principal are. Certainly when the statement is first made, there's nothing about if you act in a nefarious way, you're necessarily out of that. So that's the start of it. This is the core of the obligation of loyalty. So that's the core of what loyalty is, which, so to speak, in turn, Lord Justice Millett, as he then was in Mothew, described as a distinguishing obligation of the fiduciary. And then there's an explanation of what loyalty is. Loyalty, in this context, means being guided solely by the interests of the principal, that's, so to speak, the positive aspect of loyalty, and not by any consideration of the fiduciary's own interests, so to speak, a negative aspect of loyalty. To promote such decision-making, in other words, in order to make sure that you're acting in what you perceive to be in the principal's interests and not your own interests, you have to act openly and honestly, and mustn't place yourself in a position where your duty conflicts. But that does not mean that you cannot be loyal if you don't always act openly with your principal. You can. That brings me back to my central submission about the means, the ends justifying the means. Sometimes you can. It may not be the usual case. It may be difficult to persuade the judge that that's what you were doing. But with respect, Lord Justice Leggett is not saying here, certainly this wasn't the way it was argued, so far as we can see from the judgment, that if you do something which people would regard as, let's say, below the standards of acceptable commercial conduct, you are necessarily acting in breach of your fiduciary duty, even if you were subjectively acting with a view to enhancing your principal's interests and were entirely unaffected by any consideration of your own interests. So that's my submission on higher. The decision-making referred to in paragraph 159 is acting in the interests of the principal or the person to whom you owe fiduciary duties rather than in your own personal interests. My Lords, I promised to finish by 4:30. I may have overestimated the number of questions I might receive. I'm certainly not proposing, my generosity doesn't extend to giving the learned friend another half an hour. No. But more seriously, unless I can assist the court further, I was going to conclude my reply there. Obviously, I do that on the basis that my main submissions were the subject of extensive interchange between myself and the court.
Yes, understood. Thank you very much, Lord Wilson. Well, it won't surprise anybody to learn that we will reserve judgment in this case. We will distribute drafts in the usual way and subject to the usual embargo. Obviously, all the lawyers understand the embargo perfectly well, but I still ought to explain that it means that when the draft judgment is distributed, it is distributed only to a small circle of people who have it in order to make typographical suggestions for correction or any obvious factual corrections. There is no opportunity to re-argue the case at that stage of it in any way. And therefore, the draft is not widely distributed. If anybody wants to distribute the draft any more widely than the embargo already provides, then an application could be made for good reason, and if it's a reasonable application, it will be granted. These conditions are important orders of the court, and breach of them can be dealt with as a contempt of court and would be taken very seriously. So that's all I need to say about that. And I think that's all I need to say about anything, except to thank all counsel, all four counsel, and those behind them who have prepared the papers in such an excellent way for the conduct of this appeal, for all the assistance which you have all collectively given us. So thank you very much indeed. Very well.
All rise.